Good morning and welcome to this webinar, which is organised by the European Lawyers Foundation, the ELF, and the Council of Bars and Law Societies of Europe, the CCBE. The title of the webinar is Using the EU Charter of Fundamental Rights, What Lawyers Need to Know. My name is Jonathan Goldsmith, Senior Project Counsel with ELF. This webinar is taking place within the framework of an EU-funded project called TRAVAR, which is the short name for a project which covers the training of lawyers in various areas of EU law. We have a lot of people joining us this morning, and so while people are entering the webinar, I will make a number of important announcements. Please, will you use the question and answer box, which you will find at the bottom of your Zoom screen, to put questions to the speakers. We prefer if the questions are put in English, but we can cope if they're not, but please put them in English if you can. We strongly encourage questions. Questions will be answered, if time allows it, at the end of each session or otherwise at the end of the webinar. Please don't use the chat for putting questions. You can use that to say hello and tell us where you're from, but the actual questions for the speakers should be in the Q&A box. This webinar is being recorded, and the recording will be available on the ELF's website. The recording will only be in English, and it should be available by the end of today. There is interpretation of this webinar, though, as it's taking place, into French and Spanish. Please use the interpretation button also at the bottom of your screen if you wish to hear it in either French or Spanish. Two very important points we receive a lot of questions about. First, all the presentations that you're about to receive have got slides. They all will be uploaded onto the ELF's website. I've seen the presentations. They're packed with extremely useful information. Our speakers today may not have the time to go through everything in detail, so the slides can be consulted on the website later. We don't send them out to you. You can consult them on our European Lawyers Foundation website. Two, some of you will be looking for certificates for completing your continuing legal education. We ourselves don't provide certificates. You need to approach your bar for a certificate. We will provide your bar with a list of those who have participated, together with your connection time for those bars who ask for connection times. So don't ask us for the certificates. Approach your bar. Your bar will ask us for confirmation that you've attended. Now we can begin the webinar. It's my great pleasure to introduce the President of the Council of Bars and Law Societies of Europe, CCBE, Thierry Vickers, who will make some introductory remarks. Thierry was President of the Bordeaux Court of Appeal Bar Council in 2000 to 2001, then chaired the Conférence des Bâtonniers 2004-2005, and the Conseil National des Barreaux from 2009 to 2011. He's also one of the three authors of Règles de la profession d'avocat, which is the reference book in France for the organization and deontology of the legal profession. Thierry, over to you.
Thank you, Jonathan, and hello and good morning to everybody. It's really a pleasure to open today this webinar on the using of the EU Charter of Fundamental Rights, what lawyers need to know. First, I want to thank our co-organizers at the European Lawyers Foundation. And over the years, CCBE and Health have organized many webinars and training sessions for lawyers. They have included the digitalization of judicial proceedings, sanctions regimes, anti-money laundering, European asylum, and also immigration law. So today we will focus on another essential topic, which is the EU Charter of Fundamental Rights and its importance for lawyers. The Charter is really a key part of EU law. It protects the value at the heart of our legal systems: dignity, freedom, equality, solidarity, democracy, and the rule of law. And these are not just ideals, they are practical rights that guide our work as lawyers across Europe. As lawyers, we have a special relationship with the Charter. We are both its guardians and also its beneficiaries. We defend those rights for clients, but we can also rely on the Charter, on this right for ourselves, and especially the independence of the legal profession, the right to a fair trial, and access to justice are mentioned in the Charter. This is why today's topic is so important. It's not only about knowing what the Charter says, but it's also how can we use it in practice, in court, in our legal argument, and in defending the rule of law. And what we see is that the Charter is often underused by lawyers. Some lawyers are unsure about its scope or do not feel confident enough to use it. Today, we aim to help close that gap and try to move from theory to practice. This means that we need ongoing education and reflection on our role as legal professionals. The Charter is a living document. It's developed through case law, academic debate, and especially through the work of lawyers who apply it every day. We must also stay alert to the challenges, political, legal, or institutional, that threaten fundamental rights. In this situation, the Charter is not only a tool, but it's also a shield. It's helped us to protect our legal system and to maintain public confidence in democracy and rule of law. Today's program covers a wide range of topics. We will discuss the content and the scope of the Charter, its use at the national level, and new tools from the EU Fundamental Rights Agency. We will also hear about the Commission strategy to strengthen the use of the Charter and the relationship between the Charter and the European Convention on Human Rights and practical case studies. So it's over for me. I just want to thank our speaker for sharing their expertise, Professor Roman Tinier, Sonia Jovicic, Martina Tonskris, and Professor Tobias Locke. Your work is really vital for our understanding and applying fundamental rights. Finally, thank you to all participants for joining us from across Europe and beyond. Your interest and commitment help strengthen our shared legal culture and ensure that fundamental rights are both protected and understood. I wish you a very productive and engaging webinar. Jonathan, you have the floor.
Thank you very much, as always, Thierry. Very good. Thank you for your introduction. We now move on to our first substantive session, which is the EU Charter of Fundamental Rights, History, Content and Scope. Our speaker is Romain Tinier, Professor of Public Law at Grenoble University in France. His research areas are EU law, European human rights law, and normative interactions between legal systems. He teaches in those areas as well, and on French fundamental rights and digital transitions and fundamental rights in the EU. He's co-director of publication of the Revue des droits et libertés fondamentaux. Many publications to his name, as you would expect, including, of course, on our subject of today, the Charter of Fundamental Rights. Romain, over to you, please. Okay, and if you could share your slides, please. Perfect. Thank you.
I think everything is okay. You can hear me?
Yes.
Yes. So good morning. And thank you for this presentation. I'm very glad to be part of this training project, especially as it covers a topic that is very important to me, the EU Charter of Fundamental Rights. I suggest we start immediately, as there is a lot to cover in a relatively short time. So as you can see, we're going to talk about some general aspects of the Charter. What is its history, what is its content, and what is its scope. The objective here is to provide an overview of this instrument so that you will be able to better appreciate the subsequent presentations, which will delve deeper into some important topic. And we start with a brief history of the EU Charter with 3 main points. And first, some chronological landmarks. Like Rome wasn't built in a day, the Charter is the result of a long maturation process. 10 years after the creation of the EEC, different cases concerning fundamental rights protection began to emerge from national Supreme Courts. The most well-known case is probably the Stauder case, which concerned an allegation of a violation of human dignity by the German authorities when they applied EC law. More precisely, it was about the obligation to display the names of those entitled to reduced price butter. And the question of the German jurisdiction to the European Court of Justice was, do you have something to deal with allegation of fundamental rights violation in EC law, or should we use instead our own constitutions, which will cause a serious breach in EC law primacy? And the solution founded by the ECJ was the, let's say, discovering of general principles of law protecting fundamental rights and, more precisely, dignity. And that's why this case is so famous among European lawyers. Also because this Stauder case marks the beginning of fundamental rights protection in the EU, which would be based solely on general principles of EU law for the next 40 years, until the entry into force of the Charter in 2009. And during this time, from 1969 to 2009, so during all this time, we have some tentative to have a declaration of rights. And we have some different European Parliament reports that have been adopted, pleading for an EU Fundamental Rights Declaration. We have one EP resolution in 1979, the Gucht report, and after Herman report, but all these reports are very interesting, but without significant immediate effect. Before, the European Council took charge in 1999 in Cologne and officially launched the writing of the Charter. Proclaimed as a non-binding document during the Nice summit at the beginning of 2000, the Charter will still have to wait until the entry into force of the Lisbon Treaty to become really enforceable. So it's a relatively recent declaration of rights, the most recent in Europe. 16 years of effective application until now. And it's especially this recent charter, the charter as a recent instrument of right, is especially true in comparison with the European Convention on Human Rights. And that may explain why the charter is not as well known as it deserves to be. So since the Lisbon Treaty, the Charter is fully binding as a part of primary law according to the Article 6 TEU in its first paragraph. Due to symbolic reasons linked to the failure of the treaty establishing a constitution for Europe, the text of the Charter was not included in the treaties. It can, however, be easily found in Erlec's website along the TEU and TFEU. And as I said in the last subparagraph or Article 6.1, the Charter should be interpreted in line with its official explanations. So we have now a Charter, but why does the EU wanted a Charter? Two main reasons here may explain this decision to adopt an EU Declaration of Fundamental Rights. The first is to make fundamental rights more visible, as well as the EU's commitment to protecting them. Some observers have said that the Charter was a kind of a communication project, a marketing object of the EU around human rights. Well, maybe. However, when it comes to human rights, communication is extremely important, since you cannot invoke rights that you are unaware of. So yes, the Charter is maybe a communication project, but it's for the good. The second reason, closely related to the first one, is that the Charter was and still is a key to unlock the European integration. You cannot seriously talk about European arrest warrant or European asylum system without a strong position, a strong and clear position on fundamental rights. And that's the Charter gives to the EU. So there is two important reasons, at least, to have a Charter in the EU, but why wait so long if it's so important? Here again, two main reasons. Yeah, I'm a French lawyer, and as such, I tend to see things in two parts. But I say two main reasons. The first is the fear and the reluctance of EU member states. Fundamental rights protection is seen by member states as a means to expand EU competences. That's not fully true, because fundamental rights are much more a tool to bind the exercise of competencies than to expand them, a shield more than a sword. But what it is true is that it has expanded the European Court of Justice jurisdiction on new subjects relating to fundamental rights. The second reason is a fear too, probably less important to member states, but is a fear of competition with the Council of Europe, and more especially with the European Convention on Human Rights. And this is probably why the Charter became binding with the Lisbon Treaty at the same time as the principles of the Union's accession to the European Convention on Human Rights. And that's why enshrined in the treaty in the same article, Article 6, 6 paragraph and 1, the Charter, 6 paragraph 2, the accession to European Convention on Human Rights. Let's move now on the second part of my presentation and talk a bit about the content of this Charter. At first, about the fact that the Charter is mostly a codification project. As you can see on this slide, according to its preambles, the Charter mainly reaffirms rights. The Charter reaffirms the rights as they result, in particular, from the constitutional tradition, etc., etc. So the point here, when drafting the Charter, was not to create new fundamental rights, but to enshrine existing rights in a formal text. And that's why I think we can talk about a codification project. So if we talk about codification, what are its sources of inspiration? The main source of inspiration are the EU general principle of law and their sources of inspirations, which include European Convention on Human Rights and the European Court of Human Rights case law, which is very important to the Charter, the constitutional tradition of the different member states, and some international conventions on human rights, as, for example, the Convention of New York about the rights of the child. There is also the social charters from EU and from the Council of Europe, and EU legislation, especially for the social rights enshrined in the Charter. So it was all these sources that enabled the drafters to identify and formulate the various rights enshrined in the Charter. You can find these different sources in the official explanation of the Charter, article by article. And I think it can be useful to better understand the meaning of the different rights and the way they can be interpreted by the European Court of Justice. So, a codification project. But what are the rights protected by the EU Charter? You can see on this slide the general architecture of the Charter. Fundamental rights are gathered in 7 chapters, called titles in the Charter, to be precise, 6 thematic chapters, and in chapter 7, let's say the instruction manual, called general provisions. And let's have a quick look at these different chapters. So first, dignity. And you have here on your screen the 5 rights present in this first chapter. So the first chapter is about human dignity with 5 very important fundamental rights. Just one example, Article 4, prohibition of torture and inhuman or degrading treatment or punishment. This Article 4 has exactly the same wording and the same meaning as the much more famous Article 3 of the European Convention on Human Rights. And this right plays, to give you an example, an important role in mutual trust litigation in the EU, and particularly concerning asylum seekers' standard of receptions and European arrest warrant enforcement, considering detention conditions in the issuing member states. Let's move to the chapter 2, devoted to liberties. This second title of the Charter includes a lot of first-generation rights. And here too, the European Convention on Human Rights was a very important source of inspiration. Here, just one example, because we don't have the time to see all rights, and could be about boring. Just one example, the protection of personal data, Article 8, which is often presented as the main added value of the Charter compared to the European Convention on Human Rights. It's not fully true, as the European Court of Human Rights protects personal data through the protection of private life. But one must acknowledge that the protection of this right by the European Union is far more efficient than we have in the European Convention on Human Rights system. And thanks also, I think, to the GDPR. So, freedom. Let's move to the third chapter, which is about equality. And here we can just pick one article, Article 21, as most used of this, most invoked of this chapter, which is about non-discrimination and rights that can virtually cover any type of discrimination and does not need, compared to Article 14 of the European Convention on Human Rights, to be invoked along another right. Chapter 4, this chapter is a place of social rights and also of some of the less normative disposition of the Charter. We're going to talk about that a bit later. To be fair, let's take 2 quick examples. One, which is a real right, the other one, which is maybe less than a real fundamental right. So first example, a right, it's Article 31 on fair and just working conditions, which contains the right to annual leaves, a real and fully enforceable right, which is, yes, quite frequently used in the case law of the European Court of Justice and in some member states. As far as I know, it's a case in France. And a second example, Article 27, on workers' rights to information and consultation within the undertaking, which is not, strictly speaking, a real right, in spite of its name, workers' right. But we will talk about that just a bit later, as I say. But here you have all the social rights of the Charter. Chapter 5 is devoted to citizens' rights. And I think it's maybe less useful to national lawyers, but I did not say useless, but I think less useful than other chapters of the Charter. And especially the following one, the Chapter 6, justice. Last but not least, procedural rights, and especially the right to an effective remedy and to a fair trial. Are, you know that, I think, the key to an effective protection of fundamental rights. And as such, Article 47 is by far the most invoked right before European Court of Justice. Also because it is maybe the, let's say, the fundamentalized version of the old right to a judge, which was a prerequisite, very important for effectiveness of general EU law in the member states. So this Chapter 6 is very important, and you have both this Article 47 and after article maybe more about, let's say, defense rights. And last, finally, the how-to book of the Charter, Chapter 7, and especially Articles 51 and 52, which are maybe the most important article in the Charter to understand the way it works. And we will discuss in a moment some specific disposition of those two articles. So as I say, you have a lot of rights, but all the articles of the Charter are not about, strictly speaking, rights. They're also about other kind of norm. That's why I talk about a Charter of rights and principle, and I think that's why we can talk about normative heterogeneity of the Charter. And this is especially seen in Article 52, paragraph 5. As you can see on your screen, principles may be judicially cognizable only in the interpretation or review of acts that implement them. Unlike right, the benefit of their content cannot simply be enjoyed by judicially invoking them. They are something else, that subjective rights. The official explanation relating to this article tries to give some explanations and some examples about this difference. As you can see on your screen, principles may be implemented through legislative or executive acts, and accordingly they become significant for the courts only when such acts are interpreted or reviewed. They do not, however, give rise to direct claims for positive action by the Union's institutions or member state authorities. Let's take some example to try to understand. I'll say the explanation relating to Article 52. You have a different illustration. Article 25 is identified here as containing a principle. Here is Article 25, the rights of the elderly. It is somehow, when you read this article, it is somehow obvious that this provision was not intended to produce judicial effect. Recognition and respect are important, but are not enforcement. And especially when you compare this wording to another article of the Charter containing a subjective right, as Article 6, you have here. You can see everyone has the right to liberty and security of person. It's not exactly the same wording as the Union recognizes and respects the rights of the elderly to lead a life of dignity and independence. Article 33 is given as an example by the explanation as an article which contains a right and a principle. You have the first paragraph, the family should enjoy legal, economic, and social protection, which obviously is not a proper substantive right. And the second paragraph, which is, the wording is much more like a real fundamental right. As you can see, to reconcile family and professional life, everyone should have the right to protection from dismissal for a reason connected with maternity, and the right to pay maternity leave and to parental leave following the birth or adoption of a child. So you can have a mixed content in some articles of the Charter. The problem is that those examples are only examples. We do not have an exhaustive list of rights and principles in the Charter. The drafter didn't do that work. And as Article 25 shows, we can have a principle called rights. So we need some criteria to distinguish between rights and principles and to be sure of what are the effects of one article of the Charter. We can find those criteria in the case law of the European Court of Justice. As a matter of fact, the ECJ avoids the expression principle, but has built a distinction based on the efficiency of the norm invoked, resulting mostly from its wording. According to this, a right is a provision conferring on individual a subjective right that can be invoked as such, or in other case, which is as regard its very existence, both mandatory and unconditional in nature. This phrasing is come from Bauer case in 2018. And conversely, to the right, principle is a provision which, in order to be fully effective, must be clarified by provisions of union or national law. Is not mandatory and unconditional as regards its very existence. Here, two examples. And you have an example for rights. Article 31, paragraph 2. Every worker has the right to limitation of maximum working hours and to daily and weekly rest period and to an annual period of paid leave. And that was the last part of this article, the right to an annual period of paid leave that have been identified as a real right by the European Court of Justice in the Bauer case. Principles, you have another example, it's Article 27. Workers' rights to information and consultation within the undertaking. So for the European Court of Justice, this Article 27 is not a real right. It's a provision that needs to be clarified by provision or union or national law. And as you can see in the Article 27, the wording of the article is more or less clear about that question, because in the end of the article, you have under the condition provided for by union law and national law and practices. So it's not a real right, and for the court, it's not mandatory and unconditional as regards its very existence. To be honest, it's mainly in chapter 3 and 4 that we can find the majority of those principles or provisions that must be clarified. And these distinctions is even more important considering its concrete consequences. Rights have full direct effect when principles have only a limited effect. So as you can see, there is a significant normative heterogeneity in the Charter. It's very important to know the type of provision you're dealing with. One last word about the content of the Charter. As the court say in its case, Central Israelitisch Consistorië van België, in 2020. Like the European Convention on Human Rights, the Charter is a living instrument, which must be interpreted in the light of present-day conditions and of the ideas prevailing in democratic states today. That means that the fundamental rights standard in the EU is set to evolve according to the interpretation of the European Court of Justice. Fundamental rights do not wear out when they are exercised, and the more Charter's provisions are invoked, the more the Court will have the opportunity to interpret them and adapt them to present-day conditions. And from this perspective, the fact that the Charter is mostly a codification of existing legislation does not stop the Court of Justice from using it as a foundation for establishing a more stringent level of protection. In other words, the added value of the Charter lies not in the level of protection it defines in its wording, but in the fact that it provides the court with a legitimate instrument to ensure an effective protection. Let's move now to the third and last part of my presentation about the scope of the EU Charter. And first, the question of limitation of rights. This principle of the limitation of rights is enshrined in the Article 52, first paragraph of the Charter. It is formulated in a very traditional manner, drawing inspirations from the inspirations and the limitation clauses found in the European Convention on Human Rights. So you have, for most rights, they can be limited, and this limitation must follow 4 criteria. These 4 criteria are very traditional, nothing really new here for you, except maybe the respect of the essence of right. I just give you the 4 criteria: be provided by law, respect the essence of the right, meet general interest objective, and respect the principle of proportionality. So nothing really new, except this notion of respect the essence of the right. Just a few words about that condition. This condition, respect the essence of the right, refers to respect for the intangible part of each fundamental right. To understand this, we can use the image of a fruit kernel. This kernel, this core, is protected from any interference, regardless of the motive or the general interest objective. And from this perspective, intangible rights can be considered as fruits consisting solely of a core, a kernel. And they are intangible rights in the Charter, even if they are not specifically identified by the Charter. They can be found in particular in the first title, dignity, which is not quite a surprise, I think, for you. Last but not least, let's move to the scope of application of the Charter. And this disposition permits to answer to the question, who is required to comply with the Charter? So, the Union is obviously the first to be concerned by the Charter. More precisely, all the institutions, offices, bodies, and agencies of the Union are bound by the Charter in all their actions, so including, for example, Frontex, or the European Council, the European Parliament, the European Commission, whatever. Second, the member states. The member state may be bound by the Charter. We will discuss it in a moment, but it's only in certain situations. And third, the individuals. Even it's a bit, maybe a bit surprising, individuals may also be concerned by some provisions of the Charter. Until now, the European Court of Justice has recognized the horizontal direct effect of some articles of the Charter, some provision of the Charter. Article 21 on non-discrimination, Article 31, paragraph 2, annual leaves, and Article 47 about effective remedy and fair trial.
I wonder, I know you're not finished, but we've had a number of questions, very interesting questions, including on Article 51, which you have dealt with and are dealing with. And I wonder if I could ask those questions. Thank you, whilst
Yes.
you're there. I'm going to actually put them together. Does the Charter of Fundamental Rights, this question comes from Konstantina Zivla, does the Charter of Fundamental Rights risk become a symbolic rather than a transformative legal instrument, given the limitations that you've described of its applicability under Article 51 and the uneven constitutional traditions across the member states? That's part one. And part two from Sam Emmerecht is, what exactly is the legal meaning of Article 51(1) to the member states when they're implementing union law? What exactly does that mean, and what are the consequences? Thank you.
Thank you. Okay, for the second part of your question, we are going to talk about that just now. I think it's part of the answer will come just in a few minutes. And for the first question, I think it's the same answer. The Charter is not purely symbolic. It applied to in the member states in a series of situations that I will explain just now.
We may not have the opportunity to do that.
Yes.
Axel Beelan asked also about the applicability. I don't know if you know the answer to this, sorry. Is it true that within the EU AI Act, private companies also have to follow the Charter? If you don't know the answer, don't worry.
Yes. It's not due to the AI Act of the EU. It's due to the horizontal effect of some of disposition of the Charter. There is two different answers I can give to this question. The first is that you can have EU legislation that take a fundamental right from the Charter and give more precise disposition, more precise provisions, like the AI Act or like other example, the GDPR. The GDPR took the the right of data protection and give some explanation, some precision about this right. And we have exactly the same thing in the regulation on about AI. And so, yes, private companies are forced to respect those EU regulations. And after that, concerning the Charter, more specifically, the charters apply to private companies when they have a horizontal direct effect. And that's obviously the case of Article 8 concerning the rights to data protection.
Thank you so much for answering them. And maybe, I mean, there's one more. I'm going to ask you one, and then there's one more, which you can maybe answer in writing when we've moved on. This is from Georgios Marios Damianou. It's a more general question. It's whether human rights are genuinely universal if their protection is subject to interruption or discretion. And he talks about sanctions. I assume he means the kind of EU sanctions like against Russia, but I'm not sure. Sanctions may be considered that are against the EU Convention on Human Rights, but they're applied in extraordinary circumstances. Therefore, can they really be considered universal if there's interruption or discretion, considering also the Bauer case? Thanks.
I'm sorry, but I will give you a very general answer to this question. Human rights should be universal, but obviously they are not, because when you look more precisely on the different texts protecting human rights, those texts are regional. I mean, you have the European Convention on Human Rights, and it's not binding the United States of America. So it's not universal. It should be universal, but I think it's not really in real life. We can regret this, but I think it's a true. So you have difference in different parts of the world, But in European region, I think that the European Convention on Human Rights and the Charter are on the same line. But I don't want to talk too much about that, because I think that Tobias Locke is going to talk about the relationship between EU and European Convention on Human Rights, and he will probably tackle this subject.
Thank you so much, Romain. We must move on. I know you wanted to speak more, but you've seen Romain's slides. I'm speaking now to the audience, and how full and clear they are, as has been his presentation, I must say. Very interesting. So I regret that we need to move on. The slides will be put on the website of the European Lawyers Foundation. You should be able to consult them from the end of today. Romain, we sometimes ask our speakers, and I'm going to ask you, whether if you go to the question and answer box, you can answer them in writing, you will see. And maybe when you see ones, since they've been addressed to you and very interesting questions, maybe if you could answer them in writing when we move on to the next speaker. I thank you so much for your really excellent and very interesting presentation. And I'm sorry we have to move on, but we do have other speakers and other sessions. So we move on next to our next session, which is the application of the Charter at national level. This is, and we're going to look at research and tools from the Fundamental Rights Agency. And our speaker is Sanja Jovicic. Sanja works as a legal expert on the Charter, on the Charter project at the EU Fundamental Rights Agency. Previously, she was a course director at the European Law Academy ERA, in charge of human rights training. Then before that, as a case processing lawyer at the European Court of Rights. She's been a lawyer linguist at the European Court of Justice, so she knows both sides of the tracks, and at the Koper District Court in Slovenia. Sanja, over to you, please.
Hello, good morning, and greetings from the EU Agency for Fundamental Rights in Vienna. I will be presenting today our research, data, and tools that we've developed on the EU Charter of Fundamental Rights. Just maybe first a short overview of what we do on the EU Charter. So we provide assistance and expertise in the form of legal opinions, for example, to different stakeholders, the European Union and the member states. Most often, we contribute to the implementation of the European Commission's Charter strategy, which this year will be evaluated in its midterm review. We also promote the awareness about the Charter. For example, today's event is one of those promotional activities. And every year we collect data from the member states on how they apply the EU Charter at different levels, before national courts, in the legislative process, or by national governments. And here I just put some very general findings for different levels. For example, we see that the Charter is applied before national courts quite often, and references to the charters are increasing, but sometimes they remain superficial, and the courts do not really engage in the analysis of Article 51 of the Charter. When we look at the legislative processes, there are very few references to the Charter. Procedures do mostly not explicitly call for Charter checks, and most references are superficial. And looking at the government level, there are hardly any government policies in place to promote the Charter. But the Commission has called on the EU member states to establish a Charter focal point, and we see this as a potential new opening to promote the application of the Charter at national level. A few words about our work on civic space. I think it's important to mention here also our research on how civil society organizations are experiences possible violations of their fundamental rights. We found that they have little time or opportunity for meaningful comment or engagement with draft legislation. We found that there attacks by third parties, for example, by way of strategic lawsuits against civil society, negative media reports, online verbal threats or harassment. On the other hand, we also see state interference in the work, for example, by restricting freedom of association, peaceful assembly, expression, excessive administrative checks or audits, and politically motivated funding cuts. And we also provided some recommendations to the member states and EU institutions in this regard. And as I do not have time to deal with them, I will just invite you to check the slides after my presentation. So let's look how national courts are using the Charter. So we have some policy areas where the Charter appears most often, for example, in asylum and migration, criminal law, and data protection. Some charter rights are often, most often cited, for example, Article 47, the right of fair trial and a remedy, Article 20 on equality, Article 21, the prohibition of discrimination, Article 7, right to private life, private and family life, Article 8, data protection, but also Article 41, the right to good administration. I will present some interesting cases that we found last year from the national courts. First, we'll look at how the courts analyze the scope of application of the Charter, and then we'll see how they also apply individual articles in specific cases. First, an interesting case from Austria, which concerned an environmental impact assessment not being carried out for an application to grant permission to mining. And in this case, we had the implementation of the EU directive on the assessment of the effects of projects on the environment. What the company did was that they tried to avoid an impact assessment by requesting permits for smaller pieces of land, and then the municipality complained, saying that this was a kind of abuse of the national provisions, which required a certain threshold to be passed to conduct environmental impact assessments. And the National Court used Article 47, paragraph 2 of the Charter, that to require national courts to hold an oral hearing in this case, which was not held before the administrative court. Another case from Greece, where the Council of State also held that the removal of the confidentiality of communications pursuant to national law also fell within the scope of EU law and consequently under the Charter. So we have a directive on privacy and electronic communications, which then brings the Charter into play. So this is something that the previous speaker did not have time to address. So under Article 51, paragraph 1, the Charter applies to the member states only when they implement EU law, and the Court of Justice has said that implementing EU law means acting within the scope of EU law. You would always have to have a link with an EU law provision when you apply the Charter. So the Charter does not apply in every situation as the European Convention of Human Rights and Fundamental Freedoms. You would first have to establish a link with EU law, and then you can apply the Charter. Why is this? It's because we have the principle of conferral. The EU cannot take more competencies that the member states have given to it, and the Court of Justice really makes sure that the Charter would apply only to the situations which are covered by EU law. A case from Lithuania, where the Supreme Administrative Court held that it was necessary to refer to the provisions of the Charter when an issue in the administrative proceedings fell under the direct applicable Schengen Information System regulation. A case from the Constitutional Court of Slovenia, which held that the Takeovers Act, which incorporated the takeover bids directive in national law also fell within the scope of EU law and required the application of Article 47 of the Charter. What was the case about? So national law had a presumption that the minority shareholders were not able to actually challenge a presumption. So the presumption was that the price offered to them in a takeover bid had been fair. And in this case, they lost their right to appeal. And the case ended up before the Constitutional Court, which then remitted the case back to the first and second instance court. The Constitutional Court instructed them actually to assess whether the contested national provision complied with Article 47 and eventually to make a request for a preliminary ruling to the Court of Justice in event of doubt. This is a very nice example how the Charter came into play in a national case. And then another, maybe last case here, a very strange one in my view. So in Malta, the National Court did not find a link with EU law in a case concerning the right to appeal against the decision revoking temporary humanitarian protection. It therefore decided that the Charter was not applicable. The court noted that the proceedings related to asylum applications did not involve direct references to or applications of EU law. I leave it to you to decide what would be the right way to proceed in this case. I would like to stress that we have developed a guidance on the application of the Charter. This is a short document which summarizes the Court of Justice case law on the scope of application of the Charter. It's very short and concise. It's available in all EU languages except Maltese and Gaelic. And it contains a checklist for the applicability of the Charter and a checklist for the Charter compliance. On this slide, you can see the checklist. So we put there different case scenarios where the Charter was deemed to be applicable by the Court of Justice. For example, when a new national measure is introduced to transpose specific requirements laid down in a union legal act, for example, the transposition of a directive. Another example could be when existing national law are brought within the scope of EU law, although initially they were not meant to do so. For example, the labor code or the national civil code might suddenly become also applicable from the point of view of EU law. Then sometimes EU law might give the member states discretion to deviate from fundamental rights. And in this case, they have to comply with the Charter. And very important also case is when the national courts use existing national remedies and sections to enforce EU law. So when the court is using, for example, sanctions in a VAT case, this would bring actually the Charter into play in the case. And lastly, you might have also national legal concepts which are used by EU legislator and might also fall within the scope of the Charter. For example, the term pay. If you want to learn more about the Charter, we also developed an e-learning course. Initially, this course was developed by the Dutch Ministry of Justice, and we've simply transferred it to our Moodle platform. It's available in all EU languages, except Maltese and Gaelic again. It contains a lot of materials on the Charter, and most importantly, the Charter e-guidance. So this is specifically a tool which was specifically developed for judges. It guides them through a set of questions which helps them then identify whether the Charter applies and also how to apply the Charter in a concrete case. I've put on the slide also a test username and a password if you just want to try it out. but with this login credentials, you will not be able to access the whole platform. For every member state, we also have produced a country sheet, which provides examples of the charters used for the specific member state. It shows the charter's constitutional role elements. It links to the national case law, which has a direct reference to the charter, and presents the charter added value. These documents are available in English and in the language of the country, of the relevant country. Now let's continue with the case law, with the national case law. I present here some more examples on how the national courts use the charter to give direct access to an individual right. You see there are many cases which deal with asylum, return decisions, international protection from Austria, Bulgaria, and Cyprus, and also Czechia. The principle of non-refoulement is a very important one, which keeps coming up also in the national case law. Now, maybe a few words about a case from the Netherlands, which concerned the inspection of the mobile phone of a non-EU national by the military police. And in this case, the Council of State found that actually the national law was not clear enough on the situations when this could be done and did not provide for an obligation for the public authorities also to provide reasons when they check the mobile phone of a person. And interestingly, the Council of State interpreted the Aliens Act considering Article 7, the right to privacy, and Article 8, data protection of the Charter. Another case from Luxembourg, which concerned the right to an allowance in lieu of leave not taken, which is enshrined in the National Labor Code. The National Court also considered the Court of Justice interpretation of Article 31, paragraph 2, when deciding this case. Then some examples where the national courts assessed a possible breach of the charter. In Bulgaria, the national court concluded that national law violated the applicant's right to work under Article 15 and the presumption of innocence under Article 48. In this case, a customs officer was dismissed because criminal proceedings were initiated against him for abuse of power. And in this case, the national court, by applying the charter and interpreting the directive on the strengthening of certain aspects of the presumption of innocence and of the right of persons to be present at the trial and criminal proceedings, held that actually his right to presumption of innocence and the right to work have been violated in this case. And then a case from Denmark, which was interesting. The applicant in this case was deprived of her Danish citizenship due to her involvement with the Islamic State in Syria. She was criminally convicted of supporting terrorism, and then by application of the national law, her Danish citizenship was withdrawn, and the Supreme Court held that this was okay, considering the nature and severity of the crime and her ties with Bosnia and Herzegovina, because she was also a national of that country. And it was important here actually to note that when you're deprived of a citizenship of an EU member state, then you also automatically lose EU citizenship, which is also a specific right under EU law. So when this is done, the member states must also provide valid reason for doing so. An interesting case from Germany, where the Federal Court of Justice found a violation of the right to privacy and data protection of a tenant. In this case, the landlord used video surveillance of the entry to the flat in order to prove that the tenant was subletting their flat to a third person. And in this case, it was found to be a violation of the charter. But interestingly, in other countries, this would have been allowed. For example, in my country, in Slovenia, the courts might consider this to be allowed for the purpose of proving a violation of a contractual obligation.
Sanya, we need
Yeah.
to end now, if that's okay. Sanya,
Can I finish just 1 minute? I can
1
finish.
minute, yes.
Okay. Then I will just screw through the slides. So all of these cases presented are included in the Charterpedia, so our online database where we put national and European case law, parliamentary debates, academic references. The search is done by charter article. If you want to do a more refined search, you use the case law database, which you can find on our website under tools. And here you can do, as I said, a more detailed search. If you want to understand the relationship between the ECHR and the Charter interplay, we've developed together with the Council of Europe also an online course, which is now available in several EU languages. I do not have time to speak about the statistics from the Court of Justice, but the Charterpedia is also available on an app, which you can download on your phone. And 3 years ago, we started an online forum on the application of the Charter in practice together with the European Commission. This year, it will be organized on 8 to 9 December online. Anybody can participate, and you can see here on the slide a photo of last year's panel on the EU accession to the ECHR. We had high-level speakers such as Alex Ronkes-Ackenberg and Jochen Kallewert from the Registry of the European Court of Human Rights. We also have a Charter newsletter for Charter experts. If you're interested, please let us know on our functional email that I can share in a moment. And here are some events that we are planning this year ahead of the 25th anniversary since the proclamation of the Charter. As you see, one of the important milestones are the translation of the Charter into international sign language. We'll publish our report on human rights impact assessment of legislation, and in the end of the year, we have the Charter exchange and a high-level conference organized with the Danish presidency and the European Commission. And here, a link to our website with all the information that we've developed on the Charter. Thank you very much, and I can take some questions now.
Yeah, no, there are no questions. We must move on. Thank you. Otherwise, I'd have interrupted you earlier, Sanya. Very interesting. And can I just say to all the participants, all this incredibly useful material, which you've seen on Sanya's slides with links and QR code and events, this will all be on the slides. They're all going to be available as from this evening on the ELF's website, so that's how you can. And Sanya is coming back right at the end for a very exciting session where we will have interactive polling with you, the participants. So we'll see you later, Sanya. Martina, sorry to keep you waiting. Welcome. We come now to our next session, which is the European Commission's strategy to strengthen the application of the Charter. And our speaker is Martina Turnquist, who is team leader for the Charter of Fundamental Rights unit within DG Justice and Consumers at the European Commission. Welcome, Martina, and over to you. And Vasilis, you'll do the slides. Thank you.
Thank you, and very happy to be here. Excellent that we can reach such a broad audience. I have to say that somebody is drilling a balcony behind me, so if you do not hear that,
we don't hear it much. Don't worry.
all right, excellent. That's very good. Okay, so I come, as was mentioned, from the Fundamental Rights Unit of the European Commission, and I'm the team leader for the Charter team. Our team is in charge of the implementation and application of this strategy on the Charter that the European Commission has issued. And with this, we can go on to the next slide, please. So indeed, the policy side, so to say, at the EU level of the charter-related work is that we have a dedicated European Commission strategy to strengthen the application of the Charter of Fundamental Rights in the EU. This has been issued in 2020 and it is in force for 10 years. And actually there is a typo on the slide, so not until 23, but until 2030, I say that now. And the whole purpose is that this policy document brings together the measures the European Commission intends to take with other stakeholders to support, strengthen the application of the Charter. And it is a European Commission document, so it means that it does not oblige other stakeholders, but at the same time we do give invitations to the other important stakeholder groups to follow up and to do their best to make sure that the Charter becomes a reality for all. And as you see here on the slide, we have built our strategy on 4 strands. One of them focuses on application by the member states, the second one on application and the contributing role by civil society organizations, human rights defenders and justice practitioners. And the third pillar is about using the Charter as a compass for the EU institutions themselves. And then we have a final pillar about Charter knowledge, improving the Charter knowledge of the general public. And with this, we can go on to the next slide, please, which is more about supporting the application by the member states. So even though I said that the Charter strategy is a strategy of the European Commission, it opens by acknowledging the absolute key role of the member state authorities in implementing and applying the fundamental rights of the Charter. And this concerns state authorities at the national level, at the governmental level, but then also at regional and local levels. And the idea is that the Commission partners in as much as possible with the national level authorities to support this work. And as to the concrete measures we have put forward, Sanja already mentioned that we have invited the member states to nominate what are known as a charter focal point for each member state. And this is a coordinating role, and normally the focal point comes from the national government, and they are in charge of providing information on the Charter in their country and basically improving fundamental rights coordination in the field of EU law. Then I would say an up and coming part of this work with member states is that we try to encourage the member states to use impact assessments to ensure that fundamental rights are compliant with when they transpose EU legislation. FRA is conducting interesting research about this this year, and we have also provided training to the Charter focal points on how such impact assessments can be conducted. Then a key measure under the first strand of the Charter strategy is that we issue what are known as the annual reports on the application of the Charter. These Charter reports are issued every year, usually at around December. So 10th of December is the International Human Rights Day. So they usually come out at around that time, and they provide a topical outlook into the application of the Charter in a given field of tactical importance. So far, we have issued annual reports on fundamental rights in the digital sphere in 2021, on a thriving civic space in 22, on effective judicial protection and access to justice in 23, and then, as you see here, the latest Charter report was about the application of the Charter in human rights funding, or rather about how funding to various fundamental rights actors can support the implementation and application of the Charter provisions. And then I don't actually necessarily see the lowest part of my slide, but one important strand of work under this first pillar of the Charter strategy is that the Commission has developed what is known as the Charter HEC, so the enabling condition on the Charter, and that is based on the regulation that requires member state authorities to ensure that the charter is complied with when they construct programs to implement EU funding and when they then do implement that EU funding. And these rules apply to 8 EU funds under the Common Provisions Regulation. And this is all very technical, but just to say that we have taken steps to ensure the Charter's applicability in the field of EU funding. Then I believe we can go on to the next slide, please, which is about the civil society and human rights defenders. And this is a key element of the Charter strategy as well, also mentioned by Sanja previously. Our approach is based really on this realization that civil society organizations and human rights defenders are vital for democracies where everybody enjoys their fundamental rights. They have a role in advocating fundamental rights. They have a role in speaking truth to power and also conducting, for instance, awareness raising on fundamental rights, monitoring the fundamental rights situation in their country, and so on and so forth. And because of this very important background, the Commission works with civil society. We try to take measures to enhance their protection, to support them through funding, and to engage with them so that they could also have a role in decision-making procedures, in particular at the EU level. But then we also encourage the member states to do the same. I already mentioned that our Charter report in 2022 was dedicated to thriving civic space. And this was the launch of our more detailed actions to protect civil society, to empower and protect civil society. So we followed up with a seminar series of 3 seminars and finally a report in 2023 on how they could be further supported. In 2023, we also issued this recommendation to member states that you see here about how the civil society's engagement and participation in policymaking could be ensured. And actually, yes, on the civil society strand, still, I must mention that now under this year's work program, the Commission will finally issue its own civil society strategy. So this means that the work on civil society will be taking forward, so to say, outside the umbrella of the Charter strategy. But this is just technicalities, because the key element there is that we continue to find an open European civic space very important also for the implementation of fundamental rights. We likewise partner with national human rights institutions under the second pillar. They have a very important role in bringing together governments and the civil society, and can do very important awareness raising work, for instance. And normally national human rights institutions have a mandate to promote and protect every Charter article. So they are a very important partner indeed. And one big element in our support to these actors is, of course, funding. So we have the SURF program about rights and values, and the civil society strategy I already mentioned. And just as a last piece of information on this from this field, I mentioned last year's Charter report and these follow-up Council conclusions from this year, which both address funding to fundamental rights and really underline the importance of both the EU and the member states issuing funding to civil society actors to ensure that they remain free to conduct their activities. Then we can go on to the next slide, please. Yes, and then this will be important for the current participants, I believe, because under the second strand of the strategy, we also acknowledge and underline the key role of justice practitioners. I don't need to say it here, but independent and qualified judges are really key to apply the Charter in concrete cases, because you are the only professionals judging the Charter in your daily work, and this really gives you an absolutely central role. The Charter strategy acknowledges that, as has also been said here, that courts increasingly use the Charter they increasingly request preliminary rulings in cases involving the Charter, and also the rulings from the Court of Justice of the European Union are more and more common from this field. But at the same time, we have survey results that continuously confirm that Charter knowledge remains quite low amongst national justice practitioners. And that is why the Commission supports their capacity to apply the Charter. We do this similarly as for civil society, mainly through funding. And as you might know, our funding program for justice practitioners is the Justice Program, and that is applied together with another policy strategy that is known as the judicial training strategy. We had a judicial training strategy that was valid until 24, and now colleagues are working on a new judicial training strategy. From the perspective of fundamental rights, a key element that we try to underline is this, that fundamental rights are important both in digitalized trials, but also in traditional in-person trials. And it continues to be important to apply fundamental rights standards so that in particular the rights of the vulnerable parties to proceedings are being respected. And a challenge we see in this field is that in digitalized trials, those standards do not necessarily translate automatically to the digitalized context. So there is quite a lot of space for judicial training on those elements. And regarding this, our 23 Charter report was dedicated to effective judicial protection and access to justice. And I recommend you have a look there, because it, for instance, lists all the EU law that contains provisions on effective judicial protection. And that is actually quite a bunch of laws from the EU level. So have a look. It also contains some best practices from the member state level and information on how EU funding has supported activities in this field. Interestingly, I will say a few words later about the ongoing midterm review of the Charter strategy, but I would mention here that we have already some initial consultation results, and we received 112 responses from justice practitioners to a targeted consultation concerning them. The respondents were mainly judges and public prosecutors, and they confirmed that approximately 50% of them rarely or never used the Charter, and at the same time, approximately 50% often or sometimes use the Charter in their work. They also confirmed that 29%, I believe, had participated in in-person training on the Charter, and this had practically fully been on a voluntary basis. And the consultation also reveals a call for more national training on the Charter in the national languages, and also for more Charter tools. And Sanja already had a couple of slides about the available tools on the Charter that we do have at the EU level. So it might also be an issue about raising awareness of those existing information tools that we do have. With this, we can go on to the next slide, please. Yes, indeed. So I realized that I also don't have so much time, but just to briefly say that one very important element where we work on is the Charter knowledge of staff members from the EU institutions. It is, of course, key that the Charter is applied in EU legislation when it is drafted, and we try to reach a situation where staff members would be knowledgeable about it and could conduct a full fundamental rights impact assessment when proposing EU directives and regulations. For this, we provide continuous training in-house. It is open to all EU institutions, and it takes place now approximately 4 times a year. We are also updating a guidance document you can find online, which is about taking into account of fundamental rights in impact assessments. So this is an existing document from 2010, and a new version should be made available by the end of this year. Then we also are basically undertaking this continuous reflection about how we could further involve civil society actors as contributors to the Commission legislative process, and how we could make sure that fundamental rights are really mainstreamed into all Commission policies. I already mentioned that the Charter focal points have been trained on fundamental rights and impact assessments. And one bit of information that might be particularly interesting for you is that hopefully next January or early next year, the Commission is launching 53 online courses on the Charter, and these will be freely available online. They will focus on each of the substantive articles of the Charter, and then we have 2 courses on the general provisions, and also the general courses go a bit more into detail on impact assessments and fundamental rights. Next slide, please. Yes, so the 4th slide, and I see I don't have much time, but it is about
there's a
people.
question. So finish quickly, and then I'll ask a very interesting question.
Okay, so I actually don't need to say very much about the people. You can imagine that it is very important to communicate about the Charter, to make people know what fundamental rights are, what we are actually talking about, and at the same time, this is very challenging. So when we were drafting the Charter strategy, we conducted a special Eurobarometer that confirmed in 2019 that 42% of respondents had heard about the Charter. And now we have conducted that same Eurobarometer again, and we see that in 5 years the figure has gone up to 48%. So it is not bad, but it is not great either. The Commission carried out an information campaign in 2021 about the Charter, and now, because this year marks the 25th anniversary of the Charter's proclamation, we also have a social media campaign ongoing where we highlight some specific articles approximately every 2 weeks, and this is on DG Justice's Facebook and LinkedIn accounts. And then in terms of the events you might want to follow, Sanja already mentioned this very valuable FRA European Commission Charter Exchange. It will take place this year from 8th to 9th December, and it brings together practitioners from across the EU to follow very interesting topics where the Charter has been applied in practice. So you're very much encouraged to join that. And this year, because it is the 25th anniversary, we will follow up with a high-level conference on the Charter from 10th to 11th of December, and it will also be web streamed. I have a couple of other slides. I don't know if you want to take the question now.
Let's take the question. And just to say, and follow up to what you said, this event today, and I'm very pleased we have over 400 participants, is an EU-funded training event for lawyers to raise awareness of the Charter, so falls entirely within the strategy that you were mentioning. But the question from Katarina Netto is, does this Charter strategy foresee that the EU will internationalize EU values as well, including actions to promote EU values abroad?
Yes and no. So the Charter applies always to EU bodies, agencies, and institutions. So you can, for instance, start looking into this by having a look at our previous Charter strategy from 2010, where we said that it applies always when the EU institutions act. And from then onwards, we have been highlighting that there is a need to ensure consistency between the external and internal actions. But at the same time, we have this way of working that in EU's external action, we talk about not fundamental rights, human rights. So basically there they have their own policy strategies. So the Charter policy is applied inside the EU, and we rather work to make sure that these policies are aligned, but they are not necessarily the same policies.
Thank you. And there is one more question, and this is a political question, and you may feel as a commission official you don't want to answer it, but it's worth putting because it is causing some discussion among NGOs, which is that currently within the European Parliament, there has been noise about the funding of NGOs, and it's seen as they're hostile to the funding of NGOs by the European Commission. And the question is, do you think this is an attack on democracy and human rights under the guise of financial transparency?
Well, what can I say? We are, of course, very much aware of this, and this is something that we will work on in the civil society strategy. So if anybody listening is interested in contributing to that work, the open public consultations are open now over the summer, so you can go and make your voice heard there and propose measures. There has been this discussion, and it's a mix of all kinds of feedback. So there is also a lot of underlining of the need for the Commission to make rules about the issuing of funding more transparent, and how the Commission can tackle, for instance, the abuse of funds. So this is actually a topic that we already address in the 24 Charter report that does have a little chapter on this. But at the same time, we see that funding civil society is really of utmost importance. And we know from various studies and evaluations that there just is not enough funding to go about in the European Union. And we also know from a lot of studies that the European civic space is closing. So I cannot give you a proper answer, but here are some elements.
You have given a proper answer. Thank you. Thank you for tackling it. Not an easy question to tackle for you to tackle. Thank you so much, Martina. Thank you. Sorry we couldn't finish everything. I say what I said to in relation to the others. Your slides are excellent and very full. They will be on the website. Thank you for answering the questions. We should stop now. No, not stop. So we take a pause. When we have 3-hour webinars, we always take a pause for 15 minutes. Now is our pause. Please, I'm speaking to the participants, don't depart us, come back, because really, I shouldn't say the best is yet to come, because we've had the best, but equally good is still to come, which is both the relationship between the Charter and the European Convention on Human Rights, which has been mentioned, and also we'll be having case studies with the audience participation by polling. So there's much of interest still to come. We will return at 11:45 Central European time. So it's in fact in 13 minutes. So I look forward to seeing you all then. Thank you. Right. My computer says it is 11:45 Central European Time, and so we begin again on the second part of our program. And we begin with a topic which has been mentioned quite a lot already, and so now is definitely the time to delve into it in more detail, which is the interplay between the EU Charter and the European Convention on Human Rights. And our speaker is Tobias Locke, who is Professor of Law at Maynooth University School of Law and Criminology and founding director of the Maynooth Centre for European Law, all of which is in Ireland. Although Professor Locke is originally from Germany, where he obtained most of his legal qualifications. He joined Maynooth from the University of Edinburgh, where he was a senior lecturer in EU law and co-director of the Europa Institute. His research focuses, not surprisingly, on EU constitutional and fundamental rights law, comparative constitutional law, as well as the relationship between EU law, domestic law, and international law, all of which is perfect for his session. So, Tobias, I hand over to you, please.
Well, thank you very much, Jonathan. I hope you can hear me and see the slides. I'm going to give you a quick overview of what I want to talk about. And obviously, this is a very, very vast topic, and we've only got just under 30 minutes. So we'll keep it fairly high level. Nonetheless, I want to briefly talk about the differences and overlaps between the Charter and the ECHR, the role of the ECHR in EU law, and then we'll zoom in a little bit on the potential for contradictions between the European Court of Justice, the EU Court, and the Court of Human Rights, the ECHR Court, before looking at, again, very, very briefly, the vast case law on the responsibility of EU member states for violations of the ECHR. They can be held responsible as a proxy for the EU, where the violation is actually rooted in EU law. And then I'll briefly mention that the EU wants to become a party to the ECHR, again, I should say, but we're maybe near it, but and I could talk about this for hours as well, but I just want to briefly mention that to finish up. Now, briefly, as you can see here on the map, every EU member state is also a party to the ECHR, but obviously not all ECHR states, not all Council of Europe states are also in the EU. So there is this phenomenon that the ECHR covers the entirety of the EU member states, but the EU itself is not a party to it. Now, as had been mentioned earlier, the EU first recognized fundamental rights through the CJEU, through the case law of the Court of Justice in the Stauder case in the late 1960s. And over the course of the 1970s, it started to develop some sort of a doctrine around those. And the pillar of this doctrine was always the European Convention on Human Rights. There was no human rights document at the EU level, and the ECHR was really the fallback option. And if you read the older case law, you will often see that the Court of Justice refers to Article 10 of the ECHR, freedom of expression, or it'll refer to Article 8 of the ECHR, right to private and family life, to give some credence to its claim that there is such a thing as fundamental rights at EU level, which were at the time unwritten and only recognized as general principles. Now, we have the Charter. We've had it since the 1st of December 2009 in binding force. And the ECHR is still relevant in a number of respects. The first is that those general principles, those unwritten fundamental rights, continue to exist in EU law. So the ECHR could be used to interpret those. But more importantly, the ECHR is still an important factor in the interpretation of charter rights, which are parallel or which mirror almost the rights in the ECHR. And we will look at those in a second, because obviously the drafters of the charter, the drafting process happened in 1999, 2000. the drafters of the Charter did not start with a blank sheet. What they did is they really incorporated much of the ECHR into the Charter, and to an extent that some of the rights in the Charter will be identically phrased to those in the ECHR. Some of the rights in the Charter will have been slightly rephrased, either to update them ever so slightly and give them a more modern meaning, or to adapt them to the specific context of the EU, because obviously we have a lot of cross-border relations in the EU, which the drafters of the Charter couldn't really envisage in the early 1950s. So, overview of the substantive chapters of the Charter and how far they are mirrored, perhaps, in the ECHR. And the green bit suggests that there are a lot of parallels. The red bit suggests that there isn't a whole lot out there. And you can see that obviously the ECHR was drafted as a document protecting civil and political rights primarily, and also rights of defense. And we find a lot of overlaps there when it comes to equality, solidarity, citizens' rights, so what human rights lawyers often call economic, social, cultural rights, that kind of category of rights, if you want to call it that, is not very well protected by the ECHR. And a more granular overview is here. I mean, you can go through that in your own time once you have received a copy of the slides. But, you know, if you look at the first two chapters, dignity and freedoms, there's an awful lot of overlap. There's really not much that the Charter adds. It adds human dignity as a specific right. It adds a right to the integrity of the person, a right to protection of personal data. We've had all of that before, but you know, you can see a lot of overlaps, and that's where the convention still plays a big role in helping us as EU lawyers, and obviously ultimately the Court of Justice of the EU as the ultimate arbiter of what EU law means, to understand the meaning of these specific rights. As you can imagine, if you're familiar with EU law, which undoubtedly you are, we don't get an awful lot of case law on, say, freedom of assembly or on freedom of expression. There's the odd case here and there, but obviously the Court of Human Rights will have dealt with a lot of these questions already. So there is a lot that can be learned from the ECHR here. Now, if we go to the next slide, you can see things are getting a bit less. Obviously, there are fewer overlaps here. In particular, all those cultural rights, equality rights, and workers' rights, which we simply don't find in the ECHR. And again, when we go to the next slide, you will see that the justice chapter of the Charter is very much parallel to what we can find in the ECHR and its protocols. Now, that's an important issue to mention, perhaps, if we look at Article 50, which has given rise to an awful lot of case law and continues to give rise to an awful lot of case law in the Court of Justice, the nebis in idem principle, so the right not to be tried or punished twice for the same offense, that is not protected by the ECHR as it was originally adopted, but only by Protocol number 7, Article 4, and that protocol was not ratified by every EU member state. So Germany, for instance, hasn't ratified this particular provision as far as I know, but through the Charter, which is obviously binding on the member states when they're implementing EU law, it has indirectly become binding, at least in those cases, in those cross-border cases with, you know, European arrest warrants and the like issue. So it is really quite an interesting phenomenon that, you know, that the Charter plugs certain gaps that might be there in the ECHR. It adds rights that were not in the ECHR, that we can't otherwise perhaps enforce even under our own constitutions, under our national constitution. So it is an interesting overview to be aware of. Anyway, there's obviously another important difference between the ECHR and the Charter, and that is their effects. Now, the EU Charter, by virtue of being EU law, has the potential of being directly effective in the member states. That means most of it, at least the rights, I mean, Roma earlier distinguished between rights and principles, at least the rights do not need to be implemented into domestic law to have any effects. And where it has direct effect, it benefits from the principle of primacy. That means that it trumps contradictory domestic law, and that contradictory domestic law must be disapplied in case of a conflict. And we've also got the possibility of referring cases, or national courts have the possibility of referring cases to the CJEU. The Charter is, of course, limited for the member states because it only applies when they're implementing union law. That means when they're either applying union law, be it a directive, be it a regulation, be it the treaties, or when they are deviating from them. They might restrict free movement of persons. They might restrict, very topical, the Schengen agreement, or the right to free movement without any passport checks in the Schengen zone. So you have, and in those cases, the Charter will kick in. Now, the ECHR is different. It is unlimited in scope. It covers all state action. But its internal effects, whether you can rely on it in a domestic court, what happens if the Charter, if the convention right contradicts maybe even your own constitution? What happens if the convention right, has not been implemented properly into your domestic legal order? Those effects differ from state to state. You will have some states that give very little effects to the ECHR in domestic law. It's very hard to enforce it. It's barely used in practice. And you have other states, say Austria, where the ECHR is, basically a core foundation of the constitutional order. So those are some of the differences. And obviously, you don't have references to the European Court of Human Rights only. You only have them if your country has opted into protocol number 16. And then these references are only from the highest courts, and they are not binding. The answers by the European Court of Human Rights are not binding. So you've got differences in the effect. So it's important. Oftentimes, the Charter, if you can invoke the Charter, is a much stronger hand that you can play compared to the ECHR, or even in some cases, even compared to some of your domestic protections. Now, the EU, as I just mentioned earlier, is not yet a party to the ECHR. The ECHR as such is not binding on the EU. This means you cannot go to the European Court of Human Rights and say, I'm going to sue the European Union as a respondent, and because they have violated my right to property or something like that. Is not possible. The ECHR is also not, you cannot invoke it directly in the European Court of Justice. What you have to do is rely on the Charter, or you have to rely on those general principles of EU law, which have obviously been informed and are being inspired by the ECHR. But a violation of the ECHR technically is not a violation of EU law at the same time. It's because the EU is not bound by it. However, the ECHR remains and is the main source of inspiration for those general principles, as I've said. And we have Article 52, paragraph 3 of the Charter, which is a really important provision, and sadly not always respected, or not always respected as well respected as it should be, perhaps, by the Court of Justice itself, where it says, insofar as this Charter contains rights which correspond to the rights guaranteed by the Convention, that's the ECHR, the meaning and scope of those rights shall be the same as those laid down by the said convention. So that's a very important provision. As I showed you, all the green bits, those are the corresponding rights. Now, if you don't know, and if you can't remember, there is also a document that are called the Explanations to the Charter of Fundamental Rights. It's an official, it's in the official journal of the EU, easily accessible online. And those official explanations, which were drawn up when the Charter was drafted, they tell you which rights correspond to which rights in the ECHR. So that's your best source of authority. But obviously, if you put the Charter and the ECHR next to each other, you will typically see, okay, Article 3 of the ECHR is identically to Article 4 of the Charter, the right not to be tortured, right not to be subjected to inhuman or degrading treatment. And that means, because of Article 52.3 of the Charter, because they have to be interpreted in the same way and they have the same meaning and scope being the important word here, Article 4 of the Charter, the right not to be tortured, is an absolute right. It cannot be deviated from under any circumstances. just like Article 3 of the ECHR. So the general limitation provision, which you have in Article 52.1 of the Charter, which allows you to deviate from Charter rights if you respect the essence of the right and if if the action is proportionate. That does not apply to rights that are absolute according to the ECHR. Now, so it's an important provision. Now, there is obviously you can write books about this, about complementary and contradictory case law. I don't want to go on a lot about this, but you can see a nice dynamic. And I mean, this is a slide I've been using for a while. It's about asylum cases and the Dublin regulation. And as you know, under the Dublin regulation, the asylum seeker, the refugee, has to generally apply for asylum in the country where they first enter the EU. Now, obviously, that is not always what happens, because refugees will maybe enter the EU in Greece and they make their way up to Belgium. And the question then is, can Belgium send them back to Greece for their asylum application to be processed there? Generally speaking, yes, there's a fairly automatic process that take-back process. However, there is case law by the European Court of Human Rights which says, and that's the MSS case, well, if there is a real risk that the asylum seeker will be subjected to inhuman or degrading treatment or punishment in the receiving member state, that would be Greece in this case, then the member state that is currently, where the asylum seeker currently is, cannot send them back, because it would be a violation of Article 3 of the ECHR. Now, that goes against a fundamental principle of EU law, which is mutual trust, that we have to, as member states, have to trust each other in our relations, and we have to presume that the fundamental rights standards in Estonia are at least of the same minimum standard that we require in France or in Ireland or wherever else you might want to go. That this isn't always the case in reality didn't really affect the Court of Justice's case law very much up until this case of MSS. And then the Court of Justice in NS, the blue bits in this graph are EU law, the yellow bits are ECHR law. In NS, the Court of Justice accepted this, but interpreted the Court of Human Rights case law very, very narrowly and said, well, only if there are systemic deficiencies in the member states can we deviate from mutual trust. That was then codified when the Dublin regulation was reworked. It's the so-called Dublin 3 regulation. But then another case came along, which was called Tarakel, where there was no systemic deficiency. In this case, the case was about somebody being, a family being sent back from Switzerland, which also applies the Dublin regulation, even though they're not in the EU, to Italy. Italy did not have a systemic problem with the treatment of asylum seekers, but it could be shown that where they were supposed to be sent was not suitable for a family because it was a fairly rough camp. And the Court of Human Rights said, well, look, I mean, you have to look at the individual case. It doesn't matter whether there are systemic deficiencies in the country or not. You have to look at the individual case. Will this family be subjected to inhuman or degrading treatment or punishment? Answer is yes. You cannot send them to Italy. And that Court of Justice then took that up, at least in the CK case, which was about an asylum seeker who got seriously ill in the second country that they had been to, which was Slovenia. And the Slovenes wanted to send that person back to Croatia. And the person was able to defend themselves by saying, look, I mean, if I'm sent back, the health condition is going to deteriorate to very, very seriously, so for it to constitute inhuman or degrading treatment. So you can see how this ping pong between the two courts is sometimes playing itself out. So that's the good news, right? Complementarity, nice developments, mutual influence, mutual cross-fertilization, as we academics like to call it. But there is some contradictory case law as well. And, you know, I mean, I can only touch on the very basic. I put a link in the bottom of this slide in the notes section. There is a website by Johan Kalevart, who is the expert on this, because, I mean, he works in the Court of Human Rights. And he comments on all of these divergences and on contradictory bits of case law and complementary bits of case law. So do check it out. It's very good and very accessible. I've taken these examples from him. One is on nebis in idem, which produces an awful lot of case law, as I said before. The question is a very specific one. It's mostly around tax fraud, where typically we have a tax authority giving somebody a penalty, which is done under administrative law. And then subsequently, or at the same time, they're also pursued but in the criminal courts. And the question is often, well, if I've already paid my fine, which can be very, very substantial, say I've been accused of not paying €1 million in tax, and my fine might be 300,000 or 400,000, and I've paid it, can I then still be held responsible criminally and maybe go to jail because of that? Because I've already paid. So it's, is it a nebis in idem situation, double jeopardy, as we call it in the common law? And here we can see an interesting phenomenon where, we can see that the Court of Justice doesn't always pay attention to what is happening in the ECHR, because the Court of Justice says, well, nebis in idem, Article 50, okay, yes, we have two sets of proceedings here, they're criminal in nature, but can we see if there are limitations to that right? And Article 52.1 says that it can restrict fundamental rights and so on. The Court of Justice then goes down into a proportionality assessment and says, taken together, do these penalties, the fine that you might receive and maybe the criminal penalty, which may be a jail sentence, taken together, are they disproportionate for the crime committed? The European Court of Human Rights does it completely differently. It says, well, nebis in idem in the convention does not allow for restrictions, so it's an absolute right, and therefore they figure it out differently. They say, oh, do we have to consider those two proceedings as part of one big whole, integral set of proceedings, or are they separate? If they are completely separate, violation of Article 4, Protocol 7. If they're not separate, if we can consider them to be integrated somehow, then there's no violation. So a very different approach. Often the outcome will be the same, but it's different in substance. We also have the whole issue of systemic deficiencies not having fully been worked out by the courts. You can read up on those cases in your own time. Again, the Court of Justice takes a stricter approach, is not quite as human rights friendly as the European Court of Human Rights in those cases. But there's still a bit of contradiction. It's worth, if you're working in these areas, obviously you will be familiar with this, it is always worth checking whether you've got a leg to stand on by maybe invoking the ECHR rather than the EU Charter in a domestic case. It might be more generous or it might not be. There is another huge lot of case law on what happens if you think EU law is actually incompatible with the ECHR. Because the EU is not a party to the ECHR, there's nothing much you can do. However, there is case law that's fairly well established at this stage, where in the Matthews case, the European Court of Human Rights, over 20 years ago at this stage, has said, okay, well, the convention allows convention states, obviously, to join an organization like the EU, and EU makes its own laws, it interprets its own laws, it's enforced, it has primacy and all of those things. But where a member state does that, they remain responsible for human rights compliance under the convention. And so you can take the member state to court for a violation that might be rooted ultimately in EU law. And a good example is the Bosphorus case, where we had an airline. They were subjected to sanctions, a sanctions regulation, an EU sanctions regulation. And the aircraft that the airline had was simply impounded in Dublin Airport, and it stayed there for years. Obviously, the airline was not happy about this because they were not making any money out of the aircraft. It's very expensive. So they complained that Ireland had violated their right to property. And generally speaking, Ireland was responsible. However, the Court of Human Rights introduced a presumption of compliance with the ECHR, where the member state does nothing but execute its obligations under EU law, where it has no discretion, and where, crucially, the EU as a system continues to protect fundamental rights in some shape or form in an acceptable manner, right? So Bosphorus, important case here, and then Connolly and the 15 member states. Here we have no responsibility if it's a purely EU internal situation, like here we had a civil servant he was not happy with his own employer, which was the EU, and that there's no responsibility of the member states for that. Finally, before we come to the questions, I'm conscious of there might be some, I don't know. Will the EU become a party to the ECHR? As you can see, this is a timeline. It goes back to 1979. Around that time, I think that idea was first mooted by the European Commission. It had been knocked back a couple of times by the Court of Justice. First time in 1996, the Court of Justice said EU has no competence to accede. Then the Lisbon Treaty was adopted many years later, giving the EU not only the competence, but also a duty to accede to the ECHR. That was attempted in 2013. A treaty between the EU and the ECHR ECHR member states had been pre-negotiated. There was a draft, it's called draft accession agreement. In 2014, the Court of Justice knocked that back as well for being incompatible with EU law, with the treaties, the autonomy of the EU legal order. Nothing happened much until 2023, where a revised agreement was produced. And this is where we're still stuck at this stage here. Not much has moved since, at least not officially. The EU will, however, I think, bring that new agreement to the Court of Justice in the next couple of months. And then we will hopefully have a decision on whether this can go ahead or not, maybe in the next 2 years or so. And whenever accession will happen, that'll take another few more years because it'll have to be ratified and all of that. But we're on the track again in that direction. Now, that's it for me. For now, are there any questions?
There are a couple of questions. Eleftheria Panayotou, you mentioned a very interesting tax case under ne bis in idem about where you might have civil and then criminal. She wants to know whether this is applied in any other areas of law, for example, financial services law, whether you know of any other examples.
Okay, thank you very much. I would have to lie now, but I would imagine. So it's applied. I have the other case. I have no, sorry. There is a case that I'm aware of that's very recent. It's called ENGIA, such as ENGIA, where it was applied in regulatory law, where we had the energy regulator fining an energy company for false advertising. And we had the consumer protection regulator fining the same company for the same false advertising. So you can see it applies outside the tax area of tax law. So I don't see any reason why it shouldn't apply in, say, financial services. If you have fine, and either two sets of fines for the same conduct, and they can both be administrative, or you have one administrative fine and then you have a criminal sanction as well. The important thing is that the administrative fine has to be criminal in nature. That means it has to be very, very severe. It can't just be, €100 for not filling out a form on time or something. It has to hurt, so to speak. It has to have the criminal character.
Thank you. Rupert Wolf from Austria, former president of the Austrian Bar, former president of the CCBE, asks a very pertinent question. What would change for an EU citizen if the EU joined the ECHR?
A very good question. Not a huge amount, I think, in practice for most EU citizens. One of the things that would change, I think, is that we would close some of the small gaps that are currently existent. Now, I think the main beneficiaries will actually be EU civil servants like Mr. Connolly, and I had him on the last slide, who are complaining about something and then they don't get what they want and they say it's an ECHR violation. The other big group might be big companies that are fined by the cartel authorities of the EU. Okay, you could discuss whether they should be benefiting from human rights in the first place, but they probably don't have currently got a leg to stand on in the ECHR. That might change. But for the individual citizen, I don't think a whole lot would change, to be honest.
Thank you. There are, I'll ask one more question, then we must move on. So Konstantinos Kyriakopoulos says, should there be a separate and distinct judicial body and mandatory procedure for complaints against EU member states for corresponding rights, instead of going to the ECHR and leaving it to the European Court, should I say, of Human Rights, and leaving it to the complaints for non-corresponding rights or against third countries only? In other words, that would relieve the European Court of Human Rights from its overwhelming workload and hopefully enhance human rights protection and timely resolution of complaints.
Oh, that's a good question. I don't know whether more courts are the answer to this. I mean, one thing the European Court of Human Rights will get if if the EU joins, will be an additional judge. Now, whether that will make up for the additional workload, I don't know. It'll also get a lot more money, actually, because the EU has promised to pay to match a certain percentage of the highest paying contributor. So that is actually an advantage they will have. I'm not sure that an additional court will make things better here, to be honest. Somebody has to pay for it. So I think that's the main problem that the ECHR has.
Right. Thank you. Thank you so much for your answers. I should just say, Eleftheria Panayotou thanks you for your answer to the previous questions about Nabis in Eden, and says it's interesting because much of EU financial services legislation provides for both administrative and criminal penalties, market abuse. And so it's difficult for national supervisors to choose how to prosecute in terms of these dual routes. But it's just a comment. You needn't make any further comment. Thank you to the audience for your interesting questions.
Thank you.
Thank you, Tobias, for your very interesting presentation. That was really, really good. And now we move on to our last session, and to a session which is going to rack all our nerves, because we're moving into live and interactive sessions with polling, which we have never tried before. I tell you that in advance because I hope it all goes ultra smoothly. But we welcome back Sanja Jovicic, who will now take us through some case studies on the Charter's application. And you will see that you, the participants, will be asked questions. Don't worry, it's not a test that you'll be marked on. It's really just you'll see the answers come up. You'll see what the correct answer is. Everything is anonymous. You needn't worry when you fill in the polls. You won't find your name and email address. Well, you shouldn't, because that's how we've set it up, appearing on screen or anything like that. Everything's anonymous. But if you'd please fill in the polls as Sanja takes us through, then we'll see what answers most people gave, what was the correct answer. Sanja will comment on them. And so we hopefully will have a very interesting and lively session. Sanja, over to you.
Thank you, Jonathan. So the idea of this session is to work on practical case studies, which are based on real life cases, and to have it more interactive. So to gather also your answers. And at the end, I will also give you a possible answer to the case. And I've selected 4 cases from employment, civil law, and 1 asylum case. And hopefully we'll have time to go through all of them. If not, you have my slides, and I will also tell you where to find the answers at the end of each case. So there are quite some facts in law for every case, and I will read them out for the interpreters to translate into other languages. So the first case is an employment case. Miss Brown is the sole legal heir of her husband, who has been employed by Mr. Jones since 2003, and who had died on 4 January 2013, having been unable to work since July 2012 because of illness. Mr. Jones rejected Ms. Brown's request for an allowance in the amount of 3,800 euros, which corresponded to the 32 days of outstanding paid annual leave that her husband had not taken at the time of his death. Ms. Brown brought an action before the National Labour Court seeking payment of this allowance. She argues that Article 31, paragraph 2 of the Charter has the effect of requiring the employer to pay an allowance to the workers' heirs in lieu of paid annual leave not taken. Mr. Jones claims that the relevant provisions of national law preclude such possibility. In addition, he argues that the purpose of the right to paid annual leave, which is to enable the worker to rest and to enjoy a period of relaxation and leisure, is no longer capable of being met once the person concerned has died. Let's look at EU law, relevant EU law provisions. So we have Article 31 of the Charter, paragraph 2, which states that every worker has the right to annual period of paid leave. The right to paid annual leave has its origin in various international instruments and must be regarded as a particularly important principle of EU social law. This principle is also expressed in Article 7 of Directive 2003/88. According to the case law of the Court of Justice, entitlement to paid annual leave includes entitlement to annual leave, entitlement to continued payment of normal remuneration for that period of rest, and the right to an allowance in lieu of annual leave not taken upon termination of the employment. The Working Time Directive, Article 7, provides that member states shall take the measures necessary to ensure that every worker is entitled to paid annual leave of at least 4 weeks in accordance with the conditions for entitlement to and granting of such leave laid down by national legislation and or practice. The minimum period of paid annual leave may not be replaced by an allowance in lieu except where the employment relationship is terminated. And then for you, some national law provisions. We have paragraph 7.4 of the Federal Law on Leave, which provides that if because of the termination of the employment relationship, leave can no longer be granted in whole or in part, an allowance shall be paid in lieu. And then we have section 1922, paragraph 1 of the Civil Code, saying that on universal succession, stating that upon the death of a person, devolution of an inheritance, that person's property passes as a whole to one or more than one other person's or heirs. Here is the first question for you. Does the Charter apply to paragraph 7.4 of the Law on Leave in conjunction with section 1922, paragraph 1 of the Civil Code? First answer, yes, because it involves the implementation of Directive 2003/88. Second answer, no, because according to Article 7 of the directive, member states, when allocating paid annual leave, may use their national laws and customs. Third answer, yes, the Charter has a catalog of fundamental rights that in principle always applies, as in the case of the European Convention on Human Rights. And last answer, no, the Charter does not apply to situations that are confined in all respects with a single member state. So cast your vote. Which is the correct answer?
Okay, so they're the questions. You would be able to, click against one of the answers. The vote will open now, and we will give about 20 or 30 seconds for you to click before we close the vote, and then hopefully we will see the answer coming up on the screen. Vasilis is working behind the scenes to ensure that the voting should appear. So the vote has been open. It's about to close. Please click one of the answers. And I now announce that the vote is closed. So please, Vasilis, will you do your magic behind the scenes and put up, oh, look how quickly it happened. There we go. Sanya, hand over to you to interpret the answers there.
Yes, the correct answer is A, yes, because it involves the implementation of Directive 2003/88. Under Article 51, paragraph 1, the member states must apply the Charter when they act within the scope of EU law. And here we have a national law which regulates specifically the right to paid annual leave, and it falls within the scope of the Charter. Option B is not correct. It's true that some acts, EU legislation acts, give some discretion or margin of appreciation to the member states when legislating, especially transposing EU directives. But in this specific case, sorry, I'll just move a little bit back just to look at the provisions of the directive. So you see here, its provision says member states shall take the measures necessary to ensure that every worker is entitled to paid annual leave. So it does not seem that the directive would give any kind of discretion to the states to decide whether they would give or not paid annual leave. This is an important consideration. Option C is not correct. You've heard just now from the previous speaker that the charter does not apply as the ECHR, so you have to have a link to EU law. And option D is not correct because it might be true that, for example, the treaty provisions on freedom of movement would be applicable only when the person crossed the border. But when we have the charter and legislation that harmonizes a specific field of law, in this case, the Working Time Directive, then the charter will apply also to strictly national cases. So this is also an important point for you to consider. Let's move now on to the second question, which is a word cloud, which allows for a word cloud answer. How would you assess the compatibility of the law on leave in conjunction with quoted provisions of the Civil Code with Article 31, Paragraph 2 of the Charter?
Yes, here you're to write actual words in, and we will just get, as Sanya says, a word cloud. The vote is open. Start writing very briefly. The longer you write it, the more, the less useful it is in the word cloud. Just 2 or 3 or 4 words would be absolutely fine, and then we will see the word cloud and some of the answers on which Sanya will comment. So I'm about to close the vote, so please write in your few words. Somebody's asked if you can put the slides with the civil code back up again.
Oh, sure.
Which might be helpful to do.
Sorry. No, I'm going back.
Okay, it's there. Very good. I will close the vote now. It's only a test, and so we'll see. And so, Vasilis, I know this is a little bit more complicated to get the word cloud up on the screen. If you could do that, that would be helpful for us. Then Sanya can comment on the answers. There you go. So,
I do not see the answers, but never mind.
Oh, I do. I do. Do you not see them?
No.
Well, the biggest word is compatible. That's really by quite a long way. It says compatible.
Okay.
Incompatible, smaller. The only answer that somebody says fair, and then another answer says depends if they agree or not. EU directives will always prevail. So it's, I don't know if you want, I don't know why you don't see it, but
yeah, never mind. So yes, if the national provision would prevent the payment in such a case, then yes, this would be contrary to Article 31. But we've seen the provisions. It seems that the national courts could interpret it in a way that the paid annual leave would be granted also to the heirs of this person. And on this point, we really need to consider that the Court of Justice, when interpreting this article, notes that it is actually it contains 2 elements. So you have one element is the right to leave, so the right to rest, and the other element is a financial one, so the entitlement to a payment. And so this part can be also transferred to the heirs of the person. So this financial aspect is important. Let's move to the third question. If the relevant national rules must be considered incompatible with Article 31, Paragraph 2 of the Charter, what should the national court do in a dispute between private parties? So let's assume that this provision, the national provision, cannot be interpreted in a way that is compliant with Article 31. What would happen? What can the national court do?
Same thing. Brief answer, please, in words in the text box there. And the vote is obviously open, and we'll give you some seconds to just write a brief answer, and we'll see what useful material will emerge. Okay, I'm closing the vote now. Thank you.
Okay, can you tell me what does the
When it
result
comes
say?
up, I will tell
Okay.
you. Right. Well, yes, it's the biggest word is national. Apply and disapply appear roughly equally between themselves after that. And the other words are not really useful, I would say, for me to interpret. I don't see any of the answers, I must say, because it's they don't appear, the actual word answers. I think to the extent possible, we should move to questions, Sanya, which have got just click boxes. I think that's the most, as we're testing this out. Somebody is interrupted to say that the Spanish, Vasilis, this is for you, the Spanish translator is coming over rather than me. Vasilis, can you correct that? Is it corrected now? Can somebody, Wayne, Carol, hello, can you tell me whether that's been corrected yet?
It's working, Jonathan.
Yes, it's working now. Thank you. Fine. Sorry about that. I don't. Thank you. Yes, I've had the message. People can hear me again. Right. Sonia, it might be best if you go to questions where maybe a new example, because I think the word cloud, if you're not seeing it, it's not being
Okay.
helpful. So
I'll just give them the answers.
Yes, yes, yes. So I think go to the ones where people can actually tick the box and we can see the answers. Thank you.
Okay. Yes, the answer to this question is that the national courts would have to disapply the national law, which is contrary to EU law. And why only disapply and not annul? Because the same law might be applicable in other situations which are not EU law related. Take, for example, customs duties. So the member states cannot impose customs on products coming from other EU member states, but they can do so for products coming from third countries. So this is an important point as well here. And the court of, and maybe to move to the last question, I will just give you the answer. You don't have to answer to it. So is there a duty for the national court to oblige Mr. Jones, a private individual, to grant Ms. Brown as a legal heir an allowance in lieu of paid annual leave by virtue of Article 31, paragraph 2? Yes. So the Court of Justice has held that Article 31, paragraph 2 of the Charter is directly applicable, not only in relations to the member state, but also in relation to private individuals. So this provision actually establishes an obligation for the employer to pay untaken leave also to the heirs of the deceased person. So this is a very important effect of EU law, where when you have a direct provision, depending whether you have a monist or dualist legal system, you might be able to apply the provision directly in the operative part of the judgment or use interpretation to combine, let's say, national law in a way that is compatible with EU law, or if this is not possible, the national court would have to disapply the national provision. I suggest that we move, there you go. So this is the answer to the case. It's the Bauer case, C570/16. You can find all of your answers there. Let's move to the second case, which concerns installing electricity meters in Roma districts. This is a bit more complicated, a little bit more facts for you to read. Well, I will read them out for you. So we have Ms. Dimitro, who runs as a sole trader, a grocery shop in a district inhabited mainly by persons of Roma origin. Ms. Dimitro is of Bulgarian ethnic origin. She does not define herself as being of Roma origin and is not to be regarded as such. Electricity distributor Electra installed the electricity meters for all the consumers of that district on the concrete pylons that form part of the overhead electricity supply network at a height of between 6 and 7 meters, whereas on the other districts, the meters installed by Electra are placed at a height of 1.7 meters, 70 meters, usually in the consumer's property, on the property's facade, or on the wall around the property. Ms. Dimitru complained that she was unable to check her electricity meter to monitor her consumption and make sure that the bills sent to her, which in her view overcharged her, were correct. According to Electra, the reasons for this practice are to prevent tampering with electricity meters and illegal electricity extraction, which are apparently especially common in Roma districts. Electra asserted that in its view, the damage and unlawful connections are perpetrated mainly by persons of Roma origin. Electra refuses to adduce evidence of the alleged damage, meter tampering, and unlawful connections, asserting that there are common knowledge. The practice at issue is carried out across the whole of the district, which is lived in mainly, but not exclusively, by persons of Roma origin. It applies to all the district inhabitants, irrespective of whether or not their individual meters have been tampered with or have given rise to unlawful connection, and regardless of the identity of the perpetrators of such behavior. The practice has lasted nearly 25 years. Other electricity distribution companies have given up the practice at issue, preferring to use other techniques to combat damage and tampering, and have restored the electricity meters in the districts concerned to a normal height. Let's look at EU law. We have Article 21 of the Charter, which states that any discrimination based on any grounds such as ethnic or social origin shall be prohibited. According to the case law of the Court of Justice, the concept of ethnicity, which has its origin in the idea of societal groups marked in particular by common nationality, religious faith, language, cultural, and traditional origins and backgrounds, applies to the Roma community. Then Directive 2000/43, implementing the principle of equal treatment between persons irrespective of racial and ethnic origin, provides in Article 1 that the purpose of this directive is to lay down a framework for combating discrimination on the ground of racial or ethnic origin, with a view to putting the principle of equal treatment into effect in EU member states. Some more EU law provisions. We have Article 2 of that directive entitled Concept of Discrimination, which provides for the purposes of this directive, the principle of equal treatment shall mean that there shall be no direct or indirect discrimination based on racial or ethnic origin. For the purposes of paragraph 1, direct discrimination shall be taken to occur when one person is treated less favorably than another has been or would be treated in a comparable situation on grounds of racial or ethnic origin. Indirect discrimination shall be taken to occur where an apparently neutral provision, criterion, or practice would put persons of a racial or ethnic origin at a particular disadvantage compared with other persons, unless that provision, criterion, or practice is objectively justified by a legitimate aim and the means of achieving that aim are appropriate and necessary. Harassment shall be deemed to be discrimination within the meaning of paragraph 1 when an unwanted conduct related to racial or ethnic origin takes place with the purpose of effect of violating the dignity of a person and of creating an intimidating, hostile, degrading, humiliating, or offensive environment. Article 3 of the directive states that within the limits of the powers conferred upon the community, this directive shall apply to all persons in relation to access to and supply of goods and services which are available to the public, including housing. The Court of Justice case law states that the supply of electricity is covered by Article 3, paragraph 1H of Directive 2000/43, and that provision must be interpreted as meaning that the installation of electricity meter at the final consumer's property, which constitutes an adjunct inextricably linked to that supply, falls within the scope of the directive and is subject to observance of the principle of equal treatment, which the directive lays down. And finally, national law. We have the law on energy. National law on energy, Article 3, provides that activities in the energy sector shall be regulated by the State's Commission for Energy and Water Regulation, a specialized independent state body. Article 92 provides that published general conditions shall enter into force for the final consumer, even when without express written acceptance. And Article 110 states that the electricity supplied to final consumers shall be measured by commercial measuring instruments belonging to the operator of the electricity transmission or distribution network. The operator of the electricity transmission or distribution network shall determine the type and number of the measuring instruments and equipment and the place where they are installed. And here I put also the general conditions of Electra. So the general conditions state that the commercial measuring instrument shall be placed in such a way that the customer may visually check the readings if, in order to protect the life and health of the inhabitants' property, the quality of the electricity, the continuity of the electricity supply, or the safety and reliability of the electricity supply system, commercial measuring instruments are installed in places to which access is difficult. The electricity distribution undertaking is required to ensure at its own cost the possibility of making a visual check within 3 days of a written request to that effect from the customer. As regards that possibility of carrying out a visual check, Electra general conditions provide that it will send a vehicle equipped with a lifting platform, enabling its employees to read electricity meters in an elevated position and transmit that information to the customer. In addition, it remains possible for the customer to pay to have a second meter, a checking meter installed in their home. You've seen a lot of facts, legal provisions, and now my first question to you. Is the charter applicable in the situation in question? Answer A, yes. The charter is a catalog of fundamental rights that in principle always applies, as in the case with the European Convention on Human Rights. No, because the relevant national legislation was not meant to transpose Directive 2043 into national law. No, the charter does not apply to the two situations that are confined in all respects within a single member state. Yes, because the situation falls within the scope of Directive 2000/43.
Thanks, Sonia. I have heard from Marina Nicolaou that I have not allowed enough time for voting. So you will have more time for voting now. As I said, this is the first time that we have done this. So please vote. The vote is obviously open. And I won't speak so that I can allow you to concentrate. We'll have a short period of silence whilst you read and answer the questions. Okay. I hate silence on these webinars. So please, another 5 more seconds, and then we will close the vote. Okay, close the vote, please, Vasilis, and we'll see the answers. Thank you.
Thank you for your answers. So the correct answer is D. Yes, because the situation falls within the scope of Directive 2000/43. As we've said before, the national does not have to be intended to implement EU law. It can automatically fall within the scope of EU law at some point, as in this case. Next question. Is Ms. Dimitrov able to rely on the principle of non-discrimination on the grounds of ethnic origin, even though she is not of Roma origin?
Good question. Vote open. I will stay silent for a while. This is a simple yes, no, so I don't think people need as long as before. So the vote is closed.
Yes. Yes, it's the correct answer. So according to the Court of Justice, she can claim to be discriminated by association. Although she does not belong to the Roma community, the effects of the policy in question actually affect her, although she is not a Roma person. And this line of case law is based on a previous case from the Court of Justice titled Coleman. In that case, a mother of a disabled child was also considered to have a disability by association. Let's move to question number 3. Are there matters in this case pointing to assessing the differential treatment as direct discrimination on the grounds of ethnic origin? Do you think that the person was subject to direct discrimination?
Thank you. Period of silence whilst you answer. Vote open. Okay, it's simple yes, no. Thank you.
Yes, so we have a lot of elements pointing to a possible direct discrimination based on racial or ethnic origin. So we've seen that the company has established a practice at issue only in districts in which the majority of the population is of Roma origin. The company asserted that in its view that damage and unlawful connections are perpetuated mainly by persons of Roma origin, and such assertions could in fact suggest that the practice at issue is based on ethnic stereotypes or prejudice. The company also does not seem to have adduced any evidence of the alleged damage, mirror tampering, or unlawful connections. The practice is compulsory, widespread, and lasting. I've seen that they have carried out for 25 years without distinction in all the districts, for all district inhabitants.
So yes was the right answer. I think you implied.
Yes.
Yes. Thank you.
Yes was the right answer. And so once the court establishes direct discrimination, then the burden of proof is reversed. So the company would have to prove that in this case, there was no breach of this principle. I think we can skip this question. Do we have time to move to the next case?
Yes.
Okay.
Let's do one more case. I think there's just time for one more case. Thank you,
Okay. So the answer you will find in the Shaz case, C83/14. So next case concerns the suspension of a return decision. So here are the facts. So on 15 April 2009, Mr. Madagi submitted an application pursuant to national law for a residence permit on medical grounds on the basis he was suffering from a particularly serious illness. That application was considered admissible on 4 December 2009. As a result of a decision made on 6 June 2011, Mr. Madagi's application for leave to reside was rejected on the ground that his country of origin, Nigeria, has adequate medical infrastructure to care for persons suffering from his illness. On 29 June 2011, Mr. Madagi was notified of that decision and was ordered to leave France. This decision must be classified as a return decision within the meaning of Article 3, Paragraph 4 of the Return Directive. On 7 July 2011, Mr. Madagi appealed against this return decision, stating that no appropriate treatment for his illness is available in Nigeria. Under the relevant national rules, no judicial remedy is available to Mr. Madagi to suspend the enforcement of a return decision. Now let's look at EU law. Article 19 of the Charter protects, in the event of removal, expulsion, or extradition, No one may be removed, expelled, or extradited to a state where there is a serious risk that he or she would be subject to the death penalty, torture, or other inhuman or degrading treatment or punishment. So this is an expression of the principle of non-refoulement. Article 47 of the Charter states that everyone whose rights and freedoms guaranteed by the law of the Union are violated has the right to an effective remedy before a tribunal in compliance with the conditions laid down in this article. Everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal previously established by law. Everyone shall have the possibility of being advised, defended, and represented. Legal aid shall be made available to those who lack sufficient resources insofar as such aid is necessary to ensure effective access to justice. Then we have the Return Directive. Article 3, paragraph 4 provides that for the purpose of this directive, the following definitions shall apply. Return decision means an administrative or judicial decision or act stating or declaring that the stay of a third country national to be legal and imposing or stating an obligation to return. Article 5 is worded as follows. When implementing this directive, member states shall take due account of the state of health of the third country national concerned and respect the principle of non-refoulement. Article 9 provides that member states shall postpone removal when it would violate the principle of non-refoulement or for as long as a suspensory effect is granted in accordance with Article 13, paragraph 2. Article 12 states that return decisions and, if issued, entry ban decision and decisions on removal shall be issued in writing and give reasons in fact and in law, as well as information about available legal remedies. Article 13 of the directive states that the third country national concerned shall be afforded an effective remedy to appeal against or seek review of decisions related to return, as referred to in Article 12, paragraph 1, before a competent judicial or administrative authority or a competent body composed of members who are impartial and who enjoy safeguards of independence. The authority or body mentioned in paragraph shall have the power to review decisions related to the firm, etc. Article 14 states that the member state shall, with the exception of the situation covered in Articles 16 and 17, ensure that the following principles are taken into account as far as possible in relation to third country nationals during the period of voluntary departure granted in accordance with Article 7 and during periods for which removal has been postponed in accordance with Article 9. Emergency health care and essential treatment of illness are provided. Let's look at national law provisions. Article 3 of the law on entry, residence, establishment, and removal of foreign nationals provides in paragraph 1, a national residing in France who can prove his identity in accordance with paragraph 2 and who suffers from an illness occasioning a real risk to his life or physical integrity or a real risk of inhuman or a degrading treatment where there is no appropriate treatment in his country of origin or in the country of which he resides may apply to the member state, to the minister or his representative for leave to reside in France. My first question to you again, as before, does Article 47 apply to the national procedural rules regarding the lack of suspension? Yes, the Charter is a catalog of fundamental rights that in principle always applies, as in the case with the ECHR. Yes, because this rules qualifies in the implementation of Directive 2008/115. No, because Article 13 of Directive 2008/115 does not require that the remedy provided for in Article 30 should necessarily have suspensive effect. No, this case concerns asylum, and Article 47 of the Charter guarantees the right to effective judicial protection only for civil claims in the context of a criminal prosecution.
Thank you. Vote open. Period of silence follows whilst you have the opportunity to vote. Okay, I hope I've given you long enough. So please, let's see the results.
And most of you answered correctly. Yes, it's answer B, because the rules qualify as an implementation of Directive 2008/115. You've seen in Article 13 of Directive, this article gives the member states discretion to grant temporary suspension of return decision, and the exercise by the member states of such discretion qualifies in principle as implementing EU law. Answer A is not correct. As we said before, the charter does not apply at all times as the ECHR. Answer D is not the correct answer, because Article 47 actually has a broader scope of application than Article 6 of the ECHR. Article 6 of the ECHR applies only to civil claims and criminal charges, while Article 47 is applicable also to all kinds of other proceedings, such as administrative tax proceedings. So it's way has a wider scope of application than the ECHR.
I think, Sonia, I mean, we've got.
Yes,
Yes.
I will just comment this
Okay,
this question. No need to answer. So yeah, relationship between the charter and the ECHR. You've heard previous speaker that the ECHR is not yet legally binding for the European Union. That's why the Court of Justice has a bit difficulties applying the ECHR into its law, but there is a backdoor how it can get be applied. So it's Article 52, paragraph 3 of the Charter, which states that when the rights contained in the Charter have the same content and scope as those in the ECHR, then the ECHR should be used also to interpret the Charter rights. And how would you know that they have the same content and scope? You would have to look into the explanations to the Charter. In this specific case, for example, the explanations to Article 19 say that paragraph 2 incorporates the relevant case law from the European Court of Human Rights regarding Article 3 of the ECHR. It's clearly here you see that they have the same content and scope. And if you cannot find this information in the explanations, you can always also go to the case law of the Court of Justice of the European Union to look if the relevant provisions also have the same content and scope.
I think we've got just 2 minutes left, so we should wind up. No more questions, but I don't know if you wanted to direct people to where the case studies were, I think.
Yes, so it was basically briefly mentioned on my slides. So we have developed a trainer's manual for trainers training on the EU Charter. And there we have 8 practical case studies based on the Court of Justice case law with facts, questions, relevant EU and national law provisions, and some tentative answers for the trainer. And these cases are available now in all EU languages. Thank you.
Very good. Thank you so much, Sanya. Thank you and thank you to the audience for your patience as we tried out this polling. Very good. We have come to the end of our webinar. On behalf of all the participants, I would like to give a symbolic round of applause to all our excellent speakers. Thank you so much for your contributions today and for making it a very, very interesting session. I thank you very much. I repeat to the audience that the slides and the recording will be on the European Lawyers Foundation webinar by the end of the day. Thank you so much, and I hope that you will join us in our future webinars. So thank you very much to everybody. This is the end of the webinar, and goodbye.